This is a Reconstructionist radio production. To purchase this book, go to AmericanVision.org. The Problem of Slavery in Christian America, an ethical judicial history of American slavery and racism, by Dr. Joel McDermott. Narrated by Joe Salant. Copyright 2017. Published by American Vision, Incorporated. Chapter 5. The Antebellum Climax. The Antebellum era, from one perspective, would prove little more than an extended escalation of the tensions enshrined in the constitutional settlement. In general, the South would not budge on slavery, nor the North on union. Pro-slavery held sway not only in the Constitution itself, but largely in the branches of government as well. But this was in the process of changing. When forces of anti-slavery finally gained control in both the U.S. Congress and executive, the South saw the handwriting on the wall and attempted to secede. States' rights may have adorned the rhetoric of secession, but slavery formed the central and, one could even argue, sole heart of the reasoning. This crisis, however, did not appear overnight in the 1860s. It had a long, slow development. Even if we do not consider the roots in laws and practices that reach back to the 1600s, but only after the federal government suppressed the transatlantic slave trade, we still find tremendous support for slavery throughout the South, and equally intense racial prejudice in the North and South alike. Throughout this period, the South fought to uphold state sovereignty against the federal government, yet at the same time continued expansion of slavery westward under increased federal protection, while leveraging the hypocrisy of Northern racists who lobbed moral accusations against the South. After 1831, however, the tension increased exponentially, picking up after the turning point of Nat Turner and Garrisonianism. We see the two sides grow more polarized, further wed to the more radical conclusions of their positions, and thus more radically in conflict. Beginning at least as early as 1842, Garrison regularly described the Constitution with the biblical terms a covenant death and an agreement with hell. See Isaiah 28:14 through 18. Most people understood well enough from the circumstances themselves that the Constitution produced a pro-slavery settlement at the very least, but perhaps fewer knew just how explicitly the pro-slavery forces, North and South, had worked to secure by that document the right to hold and traffic in slaves as property as much into perpetuity as possible. Something had come to light in 1840, however, that would allow that reality to change. The first ever publication of James Madison's Notes of the Debates in the Federal Convention of 1787. Most people do not know that the Constitutional Convention took place under a virtual oath of secrecy, at least an agreement that all participants would keep the proceedings secret during their lifetimes. While Madison planned all along to publish his notes, he waited until everyone involved had deceased. Only after his death did he bequeath his papers to his wife, from whom they eventually made their way into the light of day. The result was a revelation to the nation of what exactly was said in the arbitrations of that foundational meeting. For the first time, after more than half a century, Americans could read who said what exactly the delegates thought was at stake, what they were willing to fight for or not, and more. At this point in history, when abolitionism had ascended into a national spotlight, the frank discussions of slavery in that document revealed just how central and deep the constitutional compromise over slavery had been from the very beginning. The revelation certainly had an impact on Garrison. Within only a couple years of the publication of Madison's notes, he had collected and published all the damning evidence of their pro-slavery discussions in The Liberator, as well as in a separate pamphlet. He would cite these excerpts and attempt to persuade moderates of the folly of holding the Union as the highest ideal. A well-known, self-educated blacksmith, Elihu Burritt, for example, had argued that the Union must never be dissolved, calling it the Isaac of the race, in which all the nations of the earth shall be blessed. Garrison pled in response, "How, dear sir, with the Madison Papers in your hands, can you eulogize the Constitution as the Isaac of the race, or give it any countenance, either as an abolitionist or a friend of universal peace, is to me quite incomprehensible." In his utter abhorrence of Burritt's esteem for the Union and the Constitution, Garrison would respond with those words of Isaiah, "But I hear the voice of the Lord saying, your covenant with death shall be annulled, and your agreement with hell shall not stand. When the overflowing scourge shall pass through, then shall ye be trodden down by it." Radical then, as much as now, Garrison's view nevertheless highlights the fact that the U.S. Constitution embodied a compromise between two factions utterly incompatible with each other. One built upon the demand for perpetual slavery, and another on the need for national union. As time went on, both felt burdened by the other, yet refused to act in any way that would compromise their own need. The North grew more guilt-ridden over holding aloft the political claim that all men are created equal and endowed with the inalienable rights of life, liberty, and the pursuit of happiness, while remaining unequally yoked to half of a nation that utterly trampled that claim. As this sentiment grew and found greater public expression, the South grew increasingly fearful that a national government, dominated by such Northerners, would move swiftly to emancipate the slaves and end their power and wealth. The growing tension led to what historians call sectionalism between North and South, and it describes the political war that began even before the Constitution and erupted finally in the literal war of which we are all too familiar. Garrison realized the dark side of this agreement and thus referred to the yoke itself as America's covenant with death. He saw the evil covered by nothing more than a tissue of paper and the judgment to which it would inevitably lead if not reformed. The national legislature and the national frontier. Tension over slavery had marked the Union from its earliest days in the Continental Congress, Constitutional Convention, and the very first sessions of Congress. The uneasy resolutions reached virtually promised to be continued each time. When Quakers interjected the emancipation question in the middle of the tax debate in 1791, and when Southern representatives reacted with fierce defense, it was clear the tension would not go away anytime soon. While the Constitution had provided a 20-year window of protection for the transatlantic slave trade, it said nothing to forbid the regulation of any or all aspects of that trade. Opponents of slavery saw the avenue of regulating commerce as precisely their opportunity, and thus unleashed a flood of activism trying to install taxes, fines, and other regulations to cripple the trade. The effort, however, did little more than annoy the slave forces, which in each case adapted with relative ease. For example, anti-slavery forces secured a bill in 1794 that forbid any U.S. shipyard to outfit ships for trading in slaves and forbid any American from operating a slave-trading ship. This would seem to present a major obstacle to the trade, but American slavers routinely dodged enforcement. Even if authorities could have enforced it, it had no power over foreign ships bringing slaves. In 1800, Robert Waln of Pennsylvania introduced a petition on behalf of certain free men of color to stop the kidnapping of free blacks under the guise that they were fugitives, kidnapping blacks for the trade in general, ending the trade in general, and eventually emancipating the slaves. Rutledge of South Carolina immediately scoffed at the measure, particularly at the tactic of using the emotional appeal of fearful free blacks as the petitioners. Such petitions had come along many times before, he said. Quote, "Those gentlemen who used to come forward, to be sure, had not avowedly come forward again, but had now put it into the hands of the black gentlemen. They now tell the House these people are in slavery. I thank God they are. If they were not, dreadful would be the consequences. Already had too much of this new-fangled French philosophy of liberty and equality found its way, and was too apparent among these gentlemen in the southern states, by which nothing would do but their liberty." The power of the racist angle appears in that the petition, as presented by Waln, itself acknowledged the argument Rutledge threw in their face. It had concluded by reassuring the Southern brethren it did not demand immediate emancipation of the whole, because the black gentlemen acknowledged their degraded state and want of education would render that measure improper. A brief exchange ensued over whether it was even proper to discuss the issues. Rutledge quickly brandished the old cessation card. Quote, "So improper was it to consider this subject that some of the states would never have adopted the federal form of government if it had not been secured to them that Congress would never legislate on the subject of slavery. Inasmuch, therefore, as it might rouse the jealousy and fears of those states, the least attention paid to it might do mischief." At this point, the old alliance activated again, and Rhode Island's John Brown arose. "He did not hold a slave in the world," he said, "but he was as much for supporting the rights and property of those who did." Imagine the posture. Of course, he did not own a single slave in the world. He just had grown rich shipping slaves to those who did, as had so many of his New England slave-trading allies. Thus, it was no surprise he opposed the increased regulations of the trade that would eventually become the Slave Trade Act of 1800. Forbidding American ships did nothing to stop the trade, but only allowed foreign nations to reap the riches off of it. We want money, he candidly admitted. We ought to go no farther than what has been proposed and repeal the bills in question altogether. For why should we see Great Britain getting all the slave trade to themselves? Why not our country be enriched by that lucrative traffic? After all, the same number of slaves would be shipped and sold whether American ships participated or not. So we should derive the benefits by importing from Africa as well as that nation. The protests from South Carolina and New England alike, however, could not command the votes. The petition succeeded to committee. A few months later, the House reviewed a Senate version of the regulation bill, and a vigorous debate again ensued. This time, Brown lamented the impact of the Abolition Society, whom he termed troublesome, because they had drilled their bill into Congress and would not take no for an answer. He then offered an argument so often heard from the most interested of Southern slave owners. When considered from a moral point of view, by the operation of the trade, the very people themselves, the slaves, much bettered their condition. Given that this beneficial aspect only added to the economic return, why should a heavy fine and imprisonment be made the penalty for carrying on a trade so advantageous? He moved, therefore, to postpone the bill, but he could not prevail. When the bill eventually came up for a vote, it passed overwhelmingly, 67-5. This type of overwhelming agreement against the trade strongly indicated increasing willingness to encroach on slavery, perhaps even an eventual end to slavery altogether through legislative means. This told the slave powers, already at this early date of the Union, that they must entrench themselves in what defenses they could muster before such developments spread. Consistent with the trend, as soon as the Constitution's 20-year window expired, Congress moved to abolish the transatlantic trade altogether. By 1807, the majority existed for such a measure, and with the additional impetus of the urgings of President Jefferson, Congress did just that. The act to prohibit the importation of slaves into any port or place within the jurisdiction of the United States passed on March 2, 1807, and took effect on the earliest constitutional date allowed, January 1, 1808. Nevertheless, the votes on this bill and its related amendments passed by relatively narrow margins. The slave power was anything but dead. If it could not command Congress as is, it would look to gain new pro-slavery votes through adding new pro-slavery states. The Missouri Compromise. As tensions came to the fore again in 1819 and 1820, during the so-called Missouri Question, whether or not the U.S. would admit Missouri to the Union as a slave state, admitting her as a slave state would solidify the slave power's domination of Congress and the Senate. Admitting her as free soil would set a precedent for the interpretation of federal government's power, must laws, particularly the exclusion of slavery, established by the federal government in territories, remain binding after portions of that territory become a state? Would the state not by definition gain sovereignty in which it could then determine such questions for itself? Those opposed to slavery appealed to the example of the Northwest Ordinance of 1787, which excluded slavery and This had remained the case for the states established from that territory: Ohio, Indiana, Illinois, and later Michigan, Wisconsin, and parts of Minnesota. Pro-slavery forces appealed to Jefferson's Louisiana Purchase, which had protected slavery in that territory. This argument seemed to fail, however, as it was the very type of lasting federal provision the pro-slavery forces were attempting to thwart, and by that purchase Jefferson himself had engaged in federal overreach. Thus, the pro-slavery forces appealed to state sovereignty, but even the actions of their own most prominent member now stood against them. After a long, tense year, Henry Clay seized upon Maine's timely application for statehood as the reins of a bargain. His Missouri Compromise allowed Maine to enter as a free state just ahead of Missouri, countering the effect of additional pro-slavery senators to legislative power. Moreover, it also excluded slavery everywhere in the Missouri Territory, all the remaining Louisiana Territory renamed after Louisiana statehood, north of the southern border of Missouri, excluding that state itself. This seemed to affirm the precedent that the federal government could, in fact, establish abiding legal rules for future states, yet Southerners were willing to overlook both that and the neutralizing addition of Maine in return for the expansion and perpetuation of their domestic slave market. What apparent gains anti-slavery had made in the compromise only served to steel Southern resolve and to increase support for its institution. Worse, as Southern leaders criticized the Northern demands as the intrusion of federal power upon their property, they ignited a crusade to expand slave territory to counteract the encroachment. The mental space of the South now increased to include new potential states in the West: Texas, Florida, Mexico, Cuba, Haiti, and more. As the logic of the constitutional settlement worked itself out over the following decades, the victory of the pro-slavery forces did nothing but grow more apparent. Even if abolitionists could rejoice at the closing of the transatlantic trade in 1808, it had to ring as the hollowest of victories. Congress would open vast new territories to slavery, continue to protect slavery and the thriving domestic trade wherever they existed, overturn even the status quos of previous compromises, and even subject Northerners to the role of slave hunters on behalf of Southern owners. As Southern states continued to intensify their slave codes, national legislation seemed to walk continually in that direction as well, discouraging the hopes many had placed in it. Debates had occurred in Congress over the nature and scope of constitutional powers regarding slavery since the first session. If state and federal legislation had both proven so far hopeless, perhaps the federal judiciary could provide abolitionism a foothold. The Supreme Court of the supreme law of the land would have to decide whether this covenant favored life or death after all. The federal judiciary. The judicial branch, however, would provide little more than a string of discouragements as well. Several significant cases appeared before the court during the Antebellum period. In each case, it maintained the constitutional or legal rights of slaveholders or traffickers. In fact, by 1850, the court and the legislature would join lockstep in enforcing a pro-slavery agenda. In 1825, the Supreme Court heard a case named after a slave ship, the Antelope. This somewhat complicated case involved an American captain who had acquired, through privateering, a Spanish ship carrying somewhere between 250 and 300 Africans. Spain and Portugal registered claims against the ship as well. Some of these elements implied international law as well as constitutional. This presented an interesting opportunity for the court regarding the closed U.S. slave trade in relation to international violations of that standard. Though the trade remained legal in Spain and Portugal, the court might have ruled that all the Africans on the ship were free under the various laws banning the trade to the United States, which included the right of U.S. ships to stop slavers lurking off the American coast. Unfortunately, Chief Justice Marshall, himself a slave owner, opined that while the African slave trade was contrary to the law of nature, nevertheless no nation can prescribe a rule for others. And since this traffic remains lawful to those whose governments have not forbidden it, it therefore remained consistent with the law of nations, and cannot in itself be piracy. He ruled all Africans on the ship to be property and sent the case back to the lower court to determine their fate. Similar issues ruled the decision in the case of the famous ship the Amistad. A group of wrongfully enslaved Africans overthrew the ship's crew and took command. The ship finally landed in New England, where the slaves escaped the fate of slavery in Cuba, but not claims by Spain and others based on international treaties. The Supreme Court decided that the Africans had been illegally kidnapped and enslaved and thus should go free. But while this case had been so celebrated as a victory, it had virtually no precedential value in the law and did not threaten the institution of slavery or even challenge the legitimacy of slavery. Had the Africans on the Amistad been legitimately held as slaves under Spanish law, the court would have sent them back to Cuba. In witness of this allegation, and very little mentioned in popular discussion, the court did exactly that in one case. It determined the captain's personal slave to have been a legitimate slave and ordered that he be sent back to his servitude in Cuba. These cases dealt with ships and international law, and thus may not seem to address the issue of slaves and slavery within the U.S. as relevantly as we would like. Their precedents, nevertheless, do not bode well for more direct cases either, especially once more openly pro-slavery justices begin to fill the bench. Two cases in the early 1800s illustrates how things would proceed. In Groves v. Slaughter, 1841, the court heard a case dealing with an interstate sale of slaves in which the buyer, Groves, apparently thought a provision in his state's, Missouri, constitution would allow him to take delivery from a slave trader without paying. The trader sued in federal jurisdiction, claiming the sale fell under the Interstate Commerce Clause of the U.S. Constitution. The court held that Groves had to pay up, but with a decision based on a technicality with the state's own procedures, basically dodging the direct constitutional question. But in classic fashion, some justices took the opportunity to present personal opinions on the larger constitutional questions which would have been involved otherwise. Chief Justice Roger Taney, especially, appears to have been using the opportunity to chip away at the constitutionality of the Missouri Compromise and thereby lay a foundation for imposing a more rigid pro-slavery decision upon the nation at a future date. Another Justice, McLean, argued that the Constitution treated slaves as persons, and thus the Commerce Clause could not touch them at all. Even his position seems to have left the decision of slavery up to each state, at least for the time being. Justice Henry Baldwin countered McLean's position directly, arguing forcefully, "At the adoption of the Constitution, slaves were as much the subjects and articles of commerce with foreign nations and among the several states as any other species of merchandise. They were property for all purposes and to all intents. They were bought and sold as chattels. The property in them passed by a bill of sale, by descent, or by will, and they were sold on execution wherever slavery existed. Slaves then, being articles of commerce with foreign nations up to 1808, and until their importation was prohibited by Congress, they were also articles of commerce among the several states, which recognized them as property capable of being transferred from hand to hand as chattels. Whether they should be so held or not, or what should be the extent of the right of property in the owner of a slave, depended on the law of each state. That was and is a subject on which no power is granted by the Constitution to Congress. Consequently, none can be exercised directly or indirectly." While such opinions set no binding precedent, they did nevertheless reveal the direction the pro-slavery court would lead, or even which a more moderate court may feel pressed to interpret the Constitution, especially under certain political pressures. Such pressures would certainly come, and sooner perhaps than later. Keep in mind, in the same year the court decided the case, Madison's notes were being read for the first time by many Americans, and radical abolitionists like Garrison would be increasing their attacks on the framers' views of slavery and the value of the Union altogether. In the following year, a case would test the already strained issue of the fugitive slave laws. The Constitution had long since sealed a guarantee that any slaves escaping into a different state shall be delivered up on claim of the party to whom such service or labor may be due. This provision lacked definition, however, and as anti-slavery sentiment in the northern states grew, many people simply refused to uphold the law, and many found ways around it. In 1793, Congress had overwhelmingly passed an act to intensify the scope and enforcement of the law. It specified that any alleging owner or agent of an owner could seize any alleged slave in any state, and on oral testimony or written affidavit alone, the judge was required to send the slave back to slavery. Not only did this impose a refusal of due process and prohibition of slave testimony in states that may no longer have agreed with those provisions, it also went so far as to impose the enormous fine of $500 for anyone who sheltered or abetted the accused or hindered or obstructed the claimant. Many Northerners despised the act, but for whatever reasons, perhaps a lack of enforcement, lack of pursuit by slave owners, public awareness, etc., it did not seem to provoke major reactions for some time. Beginning in the 1820s, however, a veritable slave-catching industry had developed. In many states, kidnapping free blacks and selling them into slavery. Northern states then began to enact personal liberty laws, giving accused fugitives a right to jury trial and, in some cases, other favorable protections as well. An increase in abolitionism by the early 1840s, however, led to an intensification in such efforts. By 1842, the Supreme Court was hearing Prigg v. Pennsylvania. The Commonwealth of Pennsylvania had passed a law in 1826 making it a felony to seize blacks or mix to enslave them. In 1837, one such bounty hunter named Edward Prigg did just that and was summarily convicted. He appealed all the way to the Supreme Court. The Taney Court, led by Joseph Story, decided in Prigg that the slave owner's right to recover a fugitive was so vital that it constituted a fundamental article without the adoption of which the Union could not have been formed. The Constitution's Fugitive Slave Clause, therefore, was designed specifically to guard against the doctrines and principles prevailing in the non-slaveholding states. Story upheld this decision firmly. Quote, "We have said that the clause contains a positive and unqualified recognition of the right of the owner in the slave, unaffected by any state law or legislation whatsoever, because there is no qualification or restriction of it to be found therein, and we have no right to insert any which is not express and cannot be fairly implied. Especially are we stopped from doing so when the clause puts the right to the service or labor upon the same ground and to the same extent in every other state as in the state from which the slave escaped and in which he was held to the service or labor. If this be so, then all the incidents to that right attach also. The owner must, therefore, have the right to seize and repossess the slave, which the local laws of his own state confer upon him as property. And we all know that this right of seizure and recaption is universally acknowledged in all the slaveholding states." This meant that, to whatever extent Congress had decided, the non-slaveholding states would nevertheless have to submit to the laws governing slaves still legally enslaved in other states. The Fugitive Slave Act would stand, and whatever any state's personal liberty safeguard came against it, the Fugitive Slave Act, meaning the laws of the slaveholding state, must prevail. In essence, the law of the South was now the law throughout the United States. One exception, or at least doubt, remained, however. Story had left room in his decision for the duties of state magistrates whom the Fugitive Slave Act authorized and called to its service. This conveyance of authority, he argued, was doubtful, and thus he left a loophole for situations in which states' laws might prohibit their authorities from doing so. This open door would contribute to a wave of new personal liberty provisions across the northern states. Each new development seemed to increase the tension. In 1847, abolitionists pushed the case of John Van Zult, a conductor on the Underground Railroad in Ohio, to the Supreme Court, hoping mainly to draw greater public scrutiny to the injustice and tyranny of the fugitive slave issue. Van Zant helped transport a group of slaves from Kentucky in violation of the 1793 Act. He was convicted by the lower courts and fined the hefty sum of $500 on top of civil liability to the slave owner for the cost of one slave who got away. It was clear Van Zandt had actually violated the basic intention of the act. At issue in Jones versus Van Zandt was whether it had been properly proven that Van Zandt had adequate notice, according to the law, that the blacks he had picked up were actually slaves. The defense argued that the circuit court judge had improperly charged the jury on this point. The Supreme Court would ultimately uphold the lower court's ruling, extenuating the Fugitive Slave Act, but it was the jury charge in question that provides the interesting development. At the circuit court level, Justice McLean had addressed the defense's argument that every person in Ohio, or in every other free state, without regard to color, is presumed to be free. It would seem from this that Van Zandt should have had no reason to presume that the blacks he picked up were in fact fugitive slaves. Without formal notice of the fact, then, it seems he should not be liable to the criminal penalty of the Fugitive Slave Act. But McLean instructed the jury that this only meant he had no presumption of having notice that they were slaves based on their color alone. This left open the implication that he should have presumed the fact that they might be slaves from their color alone. While McLean did not say this explicitly, and certainly would not have intended to, and the Supreme Court did not either, it implied that Northern citizens ought to at least suspect that any random black might be a slave. This development has led to at least one modern scholar's view that Van Zandt held that whites should presume that any black might be a slave. While the court did not hold this explicitly, the ruling certainly had such an effect. It increased the risk of aiding refugee slaves. Van Zandt himself suffered financial ruin from the penalties and died shortly afterward. The ruling weakened any defense of playing dumb as to whether any given blacks in question were slaves. It also, therefore, increased the risk merely of being black, now in a northern state. A free black could be kidnapped on the mere claim that he or she was a fugitive slave, and the claim itself could be enough to force the judgment. Unless the accused could find some white to testify on their behalf, they could not testify on their own behalf. They would suffer unlawful enslavement with no further legal remedy. Virtually the only fact left in favor of the abolitionists was that some of the personal liberty laws which had passed Story's loophole and which provided a jury trial for accused blacks remained unchallenged and on the books. Despite the legal defeat, the case did succeed in presenting the shocking truth of the fugitive slave business to the public in a fresh way. This meant a minor victory, at least, for abolitionists, since their side had been argued by two powerful anti-slavery figures who would achieve national fame. Samuel P. Chase, later a senator and ultimately a powerful secretary of the Treasury under Lincoln, and William H. Seward, later the same president's Secretary of State. We will return to the immediate fallout of this development in a moment. The tipping point. While 1831 and 1832 provided a turning point culturally, it took another couple of decades to reach a tipping point. The two are certainly connected, however, as the latter developed as a direct reaction to the former. Provoked by the decisions of the Taney Court during the 1840s, sectionalism increased. Abolitionism spread and gained seats in Congress. With each advance, the The slave power, with greater paranoia, moved to add new legislative security on top of its court victories. Two major advances of pro-slavery legislation dominated the 1850s and created the tipping point mentioned. The revised Fugitive Slave Act of 1850 and the major overhaul of Western Territory policy known as the Kansas-Nebraska Act of 1854. Both of these legislative affronts and battles associated with them grew out of the South's conviction that it must turn offensive and aggressive and fight desperately for its cause in order to arrest the growth of anti-slavery sentiment before it could dominate the whole nation and shut down the institution. No one embodied that policy more than John C. Calhoun, and indeed some consider the South's policy during this period to have been merely the product of Calhoun's vision and advice. Whether Calhoun deserves full credit or not is doubtful, but he certainly stands as the most prominent and quotable representative of the South's attitude and policy at the time. That policy had arisen much earlier than this tipping point, almost as soon as abolitionism began to make national waves. Responding to a wave of abolitionist petitions at the national level, Calhoun gave a famous speech on the floor of the Senate in 1837, in which he defended the perpetual enslavement of blacks as not only a necessary evil, but a positive good. He feared abolitionism, acknowledging that a large portion of the northern states believed slavery to be a sin, already in 1833, and would consider it as an obligation of conscience to abolish it if they should feel themselves in any degree responsible for its continuance. The sons of this fanatical portion of society will grow up to hate the people and institutions of nearly one half of this union with a hatred more deadly than one hostile nation ever entertained toward another. Indeed, abolition and the Union cannot coexist. Why not? Because the peculiar institution of the South was that on the maintenance of which the very existence of the slaveholding South depends. He continued in this vein, "We of the South will not, cannot surrender our institutions. To maintain the existing relations between the two races inhabiting that section of the Union is indispensable to the peace and happiness of both." While pro-slavery advocates had argued the positive good defense for a long time, Calhoun popularized it with this speech. He made it the core of the Southern policy going forward, emphasizing it at the right time and place in a national discussion. Southern leaders had argued since the Constitutional Convention that if just left alone, the South would eventually end the institution peacefully. They would argue this way all the way up through the Civil War and well beyond. The end was always just only 20 years or so away. Calhoun's vision expressed on the Senate floor belied this claim as much as its repeated failures to come to pass. He had just said neither race could have peace or happiness until the existing system was maintained. In this system, never before has the black race of Central Africa, from the dawn of history to the present day, attained a condition so civilized and so improved. Their population growth in America alone is conclusive proof of the general happiness of the race, not just relative to his own history, but to all other systems of labor. For in few countries so much is left to the share of the laborer, and so little extracted from him, or where there is more attention paid to him in sickness or infirmities of age. This system was so superior to all the other relations between capital and labor that, if just given enough time, it will prove itself. Quote, "The political condition of the slave-holding states has been so much more stable and quiet than that of the North. I venture nothing in predicting that the experience of the next generation will fully test how vastly more favorable our condition of society is to that of other sections for free and stable institutions, provided we are not disturbed by the interference of others," said Calhoun. This was not a man looking for the end of slavery in 20 or even 50 years. This was a man representing a large section of the nation and the majority view in the South that saw the institution as it existed to be the most stable, peaceful, and happy situation as the best possible social system, and one which ought to continue into perpetuity. In order that he could not even be misunderstood as even implying the system was an evil at all, he reiterated, "I hold it to be a good, as it has thus far proved itself to be to both races, and will continue to prove so if not disturbed by the fell spirit of abolition." Calhoun's policy could possibly be dismissed as the opinions of a lone radical, even despite his massive prominence in Southern politics, were it not for the fact that the South proceeded aggressively according to it over the following decades. Abolitionism had to be headed off at the pass and stopped in its budding growth. In every manifestation it appeared before it could grow stronger in national politics. Even in cases where even prominent leaders disagreed with the positive good offensive, the force of it, combined with a solid racism, kept the expression of their opinions subdued at least, if not private altogether. The great compromiser, Henry Clay, for example, had favored some gradual emancipation scheme since he witnessed the revision of the Kentucky Constitution in 1799. He was only 22. Yet during these most crucial decades, Clay kept his opinions most circumspect, or as one historian described his position, a consistent straddle. A lifelong aspirant to the presidency, and particularly as a Whig, Clay could not afford to let slip that he opposed slavery even in the least. So he kept generally quiet on it, and when he did speak, it was of pro-slavery out of necessity. Only after his last failed attempt at the presidency, his fifth in 1848, convinced him to quit, did he finally let his true feelings out. The following year, Kentucky faced a jubilee renewal of its constitution, and Clay openly joined those calling for gradual emancipation. If it strikes us sad that the abolition of such great evil as Henry admitted American slavery to be should have to wait for private political ambitions of an individual first to be exhausted, and that after a period of 24 years the reign of racism will make clear why. Writing in 1849, Clay posited as an indispensable condition of his views of emancipation that free blacks must be removed from the state. Without it, I should be utterly opposed to any scheme of emancipation. Blacks could never live in peace, harmony, and equality. The color, passions, and prejudices would forever prevent the two races from living together in a state of cordial union. Social, moral, and political degradation would be the inevitable lot of the colored race, as nowhere in the United States are amalgamation and equality between the two races possible, it is better that there should be a separation, and that the African descendants should be returned to the native land of their fathers. By 1848, it would become clear on the national level that Southern leaders would hold nothing sacred except an agreement that the Constitution protected their slavery into perpetuity. In another famous speech given that year, Calhoun argued against an anti-slavery clause during the debates over the creation of the Oregon Territory. Here he held aloft the racist vision of labor as superior and protective of the pride of the white man. With us, the two great divisions of society are not the rich and poor, but white and black, and all the former, the poor as well as the rich, belonging to the upper class. Indeed, race-based slavery was the only question sufficiently potent to dissolve the Union and subvert our system of government, and thus the South must rise up and bravely defend herself, or sink down into base and acknowledged inferiority. The toppling of alleged idols would begin. Calhoun mused about what we should expect if some future historian would have to write if indeed the nation should split and come to ruin. What would he see as the great cause of the split? Calhoun was certain. It would be the anti-slavery provisions built into the Northwest Ordinance of 1787 and the application of that same idea in the Missouri Compromise. In other words, any check upon the spread of the slave power would, in his mind, have been the seeds of destruction. But there was an even more fundamental cause beneath them all. He will trace it to a proposition which originated in a hypothetical truism, but which, now exposed and now understood, is the most false and dangerous of all political errors. The proposition to which I allude has become an axiom in the minds of a vast majority on both sides of the Atlantic, and is repeated daily from tongue to tongue as an established and incontrovertible truth. That is, that all men are born free and equal. In the American venue, Calhoun deciphered, "We shall find the proposition differently expressed in the Declaration of Independence, that asserts that all men are created equal." The form of expression, though less dangerous, is not less erroneous. It was inserted in our Declaration of Independence without any necessity, nor had it any weight in constructing the governments which were substituted in the place of the colonial. Disabusing ourselves of this most false and dangerous of all political errors, Calhoun argued, we will see that individual liberty must be subjected for the safety of the whole. Quote, "It follows that the worst form of government is better than anarchy, and that individual liberty or freedom must be subordinate to whatever power may be necessary to protect society against anarchy within or destruction without. For the safety and well-being of society is as paramount to individual liberty as the safety and well-being of the race is to that of individuals, and in the same proportion, the power necessary for the safety of society is paramount to individual liberty. This power, he argued, must increase or decrease in proportion to the intelligence and virtue or stupidity and corruption of the individual. For the lowest condition, that is, slaves, absolute and despotic power becomes necessary on the part of the government and individual liberty extinct. Thus, he felt he had proven as nonsense the idea that all men are created equal, and thus not all are entitled to liberty and equality before the law. Instead, then, of all men having the same right to liberty and equality as is claimed by those who hold that they are born free and equal, liberty is the noble and highest reward bestowed on mental and moral development, combined with favorable circumstances. Instead, then, of liberty and equality being born with men, instead of all men in all classes and descriptions being equally entitled to them, they are high prizes to be won. It was precisely this error which had strong hold on the mind of Mr. Jefferson, and which led to an utterly false view of the subordinate relation of the black to the white race in the South, and to hold in consequence that the latter, though utterly unqualified to possess liberty, were as fully entitled to both liberty and equality as the former, and that to deprive them of it was unjust and immoral. Calhoun did not prevail in the contest to prohibit slavery in Oregon Territory, but his comments nevertheless solidified both the Southern attitude toward race and slavery, as well as regarding the aggressiveness and urgency with which Southerners must defend the institution. He would maintain this advice to his deathbed, and the South would follow it. Having failed with Oregon, the urgency only mounted, and Calhoun left his dying wishes with the Senate during the debates that would follow. This would occur near the end of the first of the two great legislative advances mentioned, the Fugitive Slave Act of 1850. The Supreme Court had upheld the Fugitive Slave Act of 1793, as we saw, but left open the question of the magistrates' involvement. Abolitionist-minded authorities eagerly walked through this open door. In some cases, states continued with personal liberty provisions that, while weakened, still observed the right to jury trial. In others, judges refused to enforce certain provisions against officers or to observe them themselves. As slaves streamed north into freedom, they continued to escape not only the slave states, but in many cases the slave catchers too. If the slave power would overcome this obstacle, it would either have to create a federal police agency to circumvent the state's unwilling magistrates, or else force these magistrates to perform the law by holding them criminally liable themselves. In their remaining window of control in Congress, pro-slavery forces moved to do both. The annexation of Texas in 1845 revived the perpetual debate over congressional power between slave and free states. As it had so many times before, the debate resulted in a deadlock, and, as with the Missouri Compromise, it took the peerless realpolitik of Henry Clay to break the stalemate. The result was the Compromise of 1850, part of which included admitting Texas as a slave state and California as a free state. It also abolished the slave trade in Washington, D.C., in exchange for tightening the controls of the Fugitive Slave Act. This 1850 provision to the 1793 Act imposed particularly onerous burdens on slaves, obviously but potentially on all northern citizens. First, it empowered all federal court commissioners and marshals to do what was originally left to local magistrates. Second, it allowed these to appoint officers and agents as well as to create new commissioners to perform the work of tracking, arresting, detaining, and processing alleged fugitives. Should any marshal or deputy refuse to execute the warrants issued, they could be fined up to $1,000. The law also imposed on them the financial responsibility for slaves who escaped them after capture. It also closed the story loophole. It refused the accused slave testimony to be allowed in any trial whatsoever, allowed a claimant to recover an alleged fugitive on his testimony alone, and forbid interference from any process issuing from any judge, court, magistrate, or other person whomsoever. Finally, in the new provision that probably most riled Northerners, commissioners or their agents could summon any local posse or bystander, and all good citizens are hereby commanded to aid and assist in the prompt and efficient execution of this law whenever their services may be required. This meant that no one, no matter their beliefs or conscience, not even an abolitionist, could escape the service and deference to the slave power without stiff penalties. Not only were local and state governments forbidden from intervening, but the new federal slave tracking police force could enlist you in the business of slave recovery against your will. Calhoun, apparently unfazed by any piecemeal gains, could focus only on the doom any compromise would spell for his vision of the Union. But he was at an end. Perhaps foreshadowing the sunset of the slave power, the senator was so ill and weak he would have to have what would be his final speech read by another on his behalf. It was a great lament, a great discontent had gripped the southern states because of the long-continued agitation of the slave question on the part of the North. And why the discontent now? The great primary cause was that the North, in reality he meant anti-slavery forces in general, had grown large enough to obtain control over the federal government and thus upend the equilibrium Southerners had heretofore used to maintain the institution of slavery. When it comes to any major subject upon which the two sections might disagree, this could only mean hostility, and in particular, Calhoun had in mind the relation between the two races in the Southern section. This eventually led to Calhoun's main point. Unless something decisive is done, I again ask, what is to stop this agitation before the great and final object at which it aims, the abolition of slavery in the states, is consummated? Is it then not certain that if something is not done to arrest it, the South will be forced to choose between abolition and secession? Agitation of the slavery question was the great problem behind all the South's problems. It already snapped so many of the bonds of unity in the nation. How could this be arrested and the Union saved? Calhoun answered that the nation must satisfy the states belonging to the Southern section. How? He called for a full and final settlement, according to what he called simple justice. And what was simple justice? First, according to Calhoun, this would entail the North conceding to the South an equal right in the acquired territory. That is, let us bring in slaves to all new territories unimpeded, effectively extending slavery to all states, even new northern ones. Second, the North must do her duty by causing the stipulations relative to fugitive slaves to be faithfully fulfilled. This, of course, the North actually did in the compromise. Third, the North must cease the agitation of the slave question. In other words, politically silence all abolitionism and talk of emancipation. Finally, the North must provide for the insertion of a provision in the Constitution by an amendment which will restore to the South, in substance, the power she possessed of protecting herself before the equilibrium between the sections was destroyed by action of this government. In other words, a constitutional amendment to protect the institution of slavery permanently. Under these conditions, the Southern institution would be protected in all ways into the indefinite future, and nothing anyone said could change that. Indeed, there would be some level of promise that no one would be allowed to even agitate against it. Calhoun would not only fail to persuade the whole Senate of this radical program, he died only a few weeks later, on March 31st, 1850. He would not live to see the compromise that resulted in the fall of the same year, although he certainly would have regarded it as further doom. While the South had received the strengthened fugitive slave statute, it got nothing else he had mentioned, not even California. Further, the legislation had the opposite effect Calhoun mandated for in the North. Far from the obviously arrogant dream of pure submission to Southern interests, the North utterly recoiled at the main thing that had gone in the South's favor, the fugitive slave enhancement. The passage of the law marked a major turning point in the North, particularly for the cause of abolitionism. Received as an intrusion of the slave power into Northern life, which already was somewhat rattled by abolitionism, the shock the act generated converted hundreds of thousands of people of the North from a position of indifference or of hostility to abolition to a position of hostility towards the slave power. Far from silencing abolitionism, it induced hundreds of thousands of voters who cared very little whether the Negro was slave or free man to use all means at their disposal to stop the further extension of slavery and put an end to it whenever they could constitutionally. This public groundswell of opposition would have probably birthed immediate political results in the 1850 and 1852 congressional elections had not the Whig Party, precursors to the Republicans, split and then begun to crumble, and the remaining opposition splintered precisely when it was needed to organize against the Democrats. The Democrat Party suffered as well, having to settle on the feckless and damaged Franklin Pierce after a whopping 49 ballots at the convention. This was surpassed only by the hopelessness of the Whigs, who took 53 to agree on the aging General Winfield Scott, who had sought nomination since 1840 and failed twice. He would fail as the nominee as well. The sentiment against the 1850 compromise did not fade, however. It would fester until the next legislative affront from the South, which would come just in time for the next election. Pierce began his presidency 3 weeks after the violent, tragic death of his only remaining son, who was only 11. Rattled and already a near alcoholic, if not one, Pierce should have resigned the office. He refused even the repeated nagging of his wife to get out of politics. After the election, she spent her days as First Lady confined to her room, writing letters to the ghost of her departed son. Pierce himself would have served the nation better had he written only letters to ghosts as well, but instead he signed the product of the highly volatile debate in Congress over the admission of yet further Western territory, this time of what would become Kansas and Nebraska. After a tense and even near violent competition in both houses of Congress, enduring from winter through the spring of 1854, Pierce signed the Kansas-Nebraska Act. This made explicit what anti-slavery forces feared, but Southerners had argued was implicit since at least the 1850 Compromise, an official reversal of the Missouri Compromise. It replaced the policy of maintaining all remaining Missouri territory as free soil with that of popular sovereignty, allowing the settlers of any given territory to determine the slave status of the resulting states, championed by the slave power and its allies, most notably the Northern Democrat, Stephen Douglas. What little stability remained in the nation had rested upon the Missouri Compromise. The slave power had now prevailed in its lust, but had cut the only thread of peace that remained after 3 decades. National politics seemed to have failed. The court all but failed, the legislature now fractured and failed, and the president stumbled worse when sober than when drunk. It seemed nothing was left but an imminent crash. Barely a month after Pierce signed the act, William Lloyd Garrison keynoted a major assembly of abolitionists during a 4th of July event outside of Boston. To mark the nation's descent into its latest position, and he had prophesied for over a decade at this point, his covenant of death rhetoric climaxed in a powerful oration and performance. The slave power was prevailing, he argued. The nation had failed, and it was largely the result of the church and of the North, forces that should have been most aggressive in fighting the evil, but nevertheless had either actively or passively advanced it. Now the slave power stood poised to spread its venom across not only the nation, but all of Central America and the Caribbean as well, an old plan few people even knew, let alone took seriously, but which was very real. In the midst of his speech, Garrison held up a copy of the Fugitive Slave Act. He lit a match and set the document aflame. He moved the audience to shout, "Amen," which they heartily did. And then he produced a copy of a recent infamous court decision which enforced that law. Burning it as well, the people joined again, "Amen." But then Garrison held aloft a copy of what he called the source and parent of all other atrocities. Everyone knew what was coming. He struck the match. He conveyed the flame. It burned. Garrison had just reduced the covenant with death itself, the U.S. Constitution, to ashes. And aside from a few who were cowed by the popular feeling, the audience cheered again. Throughout the 1840s and 50s, the great wedge of slavery had fissured and cleaved the Union until something would have to give. The cracks manifested in the breakdown of integrity in Congress, where the facade of reason and order crumbled away to reveal power and hostility. On multiple occasions, heated debates erupted into fights and even the brandishing of weapons, foreshadowing the war to come. In 1842, 2 Southern representatives tried to intimidate Tennessee Whig Thomas Arnold with a Bowie knife, threatening to cut his throat from ear to ear. In a heated exchange during the Senate debate over the Compromise of 1850, Henry Foote of Mississippi, fearing for his life, pulled a gun on the charging Missourian Thomas Hart Benton. During the debates over the Kansas-Nebraska Act, a fallout over words enticed William Cullum to jump his desk after William Churchwell, who reached for a gun concealed in his pocket. A third representative grabbed his hand before he fired. The next morning, Preston Brooks of South Carolina introduced 2 resolutions mocking the members involved. One to have any member carrying a weapon removed from Congress, and a second to construct a rack outside the door where such members could store their pistols in the meantime. In the capstone of congressional violence and hypocrisy during the era, a mere 2 years later, this same Brooks would infamously beat his anti-slavery rival, Charles Sumner, almost to death with a cane on the Senate floor, while sympathetic abusers prevented anyone from approaching to intervene or to help Sumner. Tensions obviously ran at an all-time high throughout the nation. Garrison's matches may have burned documents, but with the final threads of unity cut and the lusts of the slave power still raging in defiance of even moderate anti-slavery, let alone the growing abolitionism, the whole nation became a powder keg, awaiting only for the right spark. The final judicial straw. Chief Justice Taney had remained largely in the background through all the major Supreme Court decisions to date, though he had joined and presided since 1836, and his court's agenda grew more apparent with each ruling, tightening the chains on slaves as slaves and blacks as slaves. What he had begun to set up in the early 1840s, he certainly capped with his most famous dispensation of racist jurisprudence in 1857, the now infamous Dred Scott v. Sanford decision. Dred Scott was the slave of a U.S. Army captain who had resided with Scott in both Illinois and Wisconsin, both free states, and both created out of territories in which slavery had been prohibited. Upon these and other grounds, Scott sued for the freedom of his family, including wife and child. Once the question arrived at the Supreme Court, Taney opined that one of the most pressing questions involved was whether Scott, as a slave of African descent, even had standing to sue in federal court. Dred Scott has commanded whole books to itself. This brief review can only highlight a couple relevant points. First, the case further solidified the legal precedent that slaves were property and not persons. Slave states had long since settled this question for their practices, but nationally the Constitution contained contradictory or at least ambiguous clauses. While the court had moved largely in this direction already, the effort remained unfinished. Secondly, Dred Scott would boldly attempt to make anti-black racism national policy across the board by deciding that the Constitution never intended to include blacks as citizens and that blacks by nature could never qualify as U.S. citizens. Further, it worked to solidify the total control of the slave power and the enshrinement of all its wishes on a national level. Since at least 1841, as we saw with Slaughter above, Taney had the Missouri Compromise in his sights. Could the federal government forbid slavery in U.S. territories, and particularly in such a way as to bind states created in those territories later? Taney could not let such a strike at slave power stand. The court would use Scott as the occasion to find the 1820 Compromise unconstitutional. The more famous passages Taney penned address this issue, and in order to advance the slave power ultimately had to strike at the created equality of all men. Quote, "The position is simply this: can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights and privileges and immunities guaranteed by that instrument to the citizen, one of which rights is the privilege of suing in a court of the United States in the cases specified in the Constitution," said Taney. Taney's answer represented the seared conscience of a racist nation. "We think they are not, and they are not included, and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at that time considered as subordinate and inferior class of beings who had been subjugated by the dominant race and, whether emancipated or not, yet remained subject to their authority and had no rights or privileges but such as those who held the power and the government might choose to grant them, said Taney. He went on to argue for the undisputed inferiority of blacks based upon Western history and experience. They had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. He was bought and sold and treated as an ordinary article of merchandise and traffic whenever a profit could be made by it, said Taney. After stating that the entire scope and history of the British Empire and American colonies agreed in this view of blacks, Taney concluded, and accordingly, a Negro of the African race was regarded by them as an article of property and held and bought and sold as such in every one of the 13 colonies which united in the Declaration of Independence and afterwards formed the Constitution of the United States. Thus, the Supreme Court of the United States concluded that the Constitution, and thus all federal law, could not acknowledge blacks as U.S. citizens, but merely as articles of property. Thus, Dred Scott established the legal rule that African Americans were presumptively slaves and had no rights under the Constitution. Slaves under federal law were never people. They were property without a voice in a courtroom and without rights. At one point in his opinion, Taney applied the well-worn fact that the southern states would have never agreed to union if it meant to give citizenship and rights to the slaves. Furthermore, we should all be wary of such a doctrine, because if blacks had citizenship under the Constitution, they would have immunity from the police regulations used to hold them in bondage. It would give to persons of the Negro race, who were recognized as citizens in any one state of the Union, the right to enter every other state whenever they pleased, singly or in companies, without pass or passport, and without obstruction, to sojourn there as long as they pleased, to go where they pleased at every hour of the day or night without molestation, until they committed some violation of law for which a white man would be punished. Moreover, citizenship would mean the blacks would get to exercise all the rights enumerated in the Bill of Rights. It would give them the full liberty of speech in public and in private upon all subjects upon which its own citizens might speak, to hold public meetings and comment on public affairs, and to keep and carry arms wherever they went. This would mean that the whole black population would suddenly learn that they had the right to speak out, assemble, and bear arms, inevitably producing discontent and insubordination among them and endangering the peace and safety of the state. In addition, this was an open admission by a mouthpiece of the slave power that American slavery depended ultimately on racism, aside from which all the police powers and slave codes used to oppress and subjugate the slaves would be considered unconstitutional. In hindsight, Taney seems to have genuinely believed that he could end the controversy by eliminating all question of dominance by pure imposition of power. A settlement of raw power was better than no settlement at all, apparently. But the suppression of injustice with greater injustice only fuels righteous indignation, which will spread even if only maintained by a righteous few. The slave power had spread into every venue of American law, and now the highest reach of the courts, and it thoroughly dominated the American government such that it had immunized itself against virtually every legal challenge. This was Calhoun's full and final settlement in action, and it was still not sated. Newspapers and politicians were already discussing further advances in light of Dred Scott. Even in that decision itself, one of the concurring justices had added that the court already had in view the further right of a Southern master to enter a free state voluntarily with his slaves and yet maintain them as slaves. When that question arises, we shall be prepared to decide it. After Dred Scott, it certainly appeared Garrison had been all too correct about America's covenant with death. But these dark times had not extinguished all light. The Kansas-Nebraska front had brought Stephen Douglas further into national spotlight, but as a northern champion of a pro-slavery policy. This allowed an aspiring Abraham Lincoln to challenge the popular sovereignty doctrine in public in a bid for the Illinois Senate seat in the fall of 1854. Although unsuccessful, the campaign established Lincoln as a hopeful anti-slavery candidate. The congressional election of that year saw a massive bloodletting for Democrats, who lost almost half of their seats to various opposition parties. Due to the continued realignment of the opposition, Democrats recovered temporarily in 1856. After Dred Scott, however, the stars aligned and the Democrats suffered another dramatic fallout. In fact, the New York Tribune pointed out that Taney had purposefully delayed the decision until after 1856 in order not to fragrantly alarm and exasperate the free states on the eve of an important presidential election. In 1858, predictably, anti-slavery forces dominated the House and polled even in the Senate. When Minnesota entered in 1858 and Oregon in 1859, both as free states, the South lost the Senate entirely. As Lincoln sparred with Douglas for his Senate seat in 1858, the issues of fugitive slave acts, popular sovereignty, the spread of slavery, and the multitude of injustices of the slave system recurred in each debate. But remember, Illinois was a free state, so having a pro-slavery senator like Douglas stood as a symbol of the overreach of the slave power. Lincoln lost again, but was now firmly entrenched in the national spotlight and was poised for even higher things. In this atmosphere, the entire nation would watch with trembling, in either anticipation or fear, the contest for president in 1860. In the meantime, all facets of society continued to simmer. The point of no return. If the events of the 1830s had been a turning point, and the politics of the 1850s the tipping point, the Dred Scott decision undoubtedly marked the point of no return. The North reacted in panic, and the South reacted to the North's panic with its own. Both sides went from dogged to entrenched. In the 1780s and 90s, both sides had suspicious hope of prevailing politically. By 1810, hope had diminished. By the 1830s, hope turned into activism. By the 1850s, activism turned to bitterness. After Dred Scott, hope was dead. Northern newspapers expressed fears that slavery could eventually be practiced openly within the boundaries of any free state with constitutional authority. The New York Tribune blasted the decision as entitled to so much moral weight as would be the judgment of a majority of those congregated in any Washington bar room. The Daily Times said it completes the nationalization of slavery. Ironically, the doctrine of states' rights, which had for so long been championed by the South, had actually protected the North from the slave power in many ways. This doctrine, the paper lamented for the North, so long its friend is now its foe. The Independent fumed against the wickedness of this decision, calling it a horrible handbook of tyranny, and the court the personification of persecution. The Salem Register added that the court has been wholly revolutionized by the sleepless vigilante of the slave power to impose its most obnoxious doctrines. Lincoln himself, in his famous House Divided speech in 1858, suggested that with the slave powers already wielded, the court could one day simply turn free states into slave states by virtue of fiat. Southern papers reacted with a sense of proud vindication. Through their exulting entitlement, however, bubbled precisely the imperial spirit Northerners feared. The New Orleans Daily Picayune denied that the decision set any precedent for eliminating the rights of free blacks in free states, but nevertheless added, "For our own part, we should not at all lament to see such a result brought about." A newspaper war soon erupted between President Buchanan's paper in Washington, D.C., ironically named the Union, and the New York Tribune. Buchanan's boys challenged the latter. What rights or liberty exactly had they lost? The decision, after all, had done nothing but uphold what the Constitution had enshrined all along. The Tribune stung back by citing the Declaration's claims from the rights of human nature and the Bible as follows: "We rest for the security of our rights, then, not on the fallible and fickle breath of any casual majority, whether embodied in the Constitution or not, but on the firm basis of eternal justice. The Golden Rule does prohibit us to do unto white men only as we would have them do unto us. The Good Samaritan was not commended for humanity to one of his own kith and kin, but for cherishing a wronged fellow being of a despised and detested race. A false balance is an abomination, says the good book, and what could be more abhorrent to any true idea of equity than a judgment that the outcast and downtrodden, by reason of their wrongs, shall be denied a hearing in our courts of justice, whose rights are secure when such justice is dealt out from the bench of our very highest tribunal." In response to this, the Southern partisans could only scoff about general homilies and retorted that the authors of the Declaration seemed to side with the rights of slave owners. Did Jefferson regard the Declaration of Independence as a declaration of freedom to his Negro servants? Did Washington understand that all the slaves he owned were made free by the Treaty of 83? Did Patrick Henry, when he cried, "Give me liberty or give me death," mean to say, "Give me liberty for every Virginia Negro, or give me death for myself"? Thus, they chose the sins of their fathers over the appeals to a higher law. Where the Tribune had ended by asserting that these rights of human nature know no distinction of difference Founded on this difference of origin and color, the Union concluded by taunting its rivals from the position of entrenched racist slave power. We congratulate the Tribune upon its full appreciation of its own color, but whether the rights of human nature recognize any distinction founded on color or not, it ought to remember the question before the court. The question before the court was whether any such distinction was recognized by the Constitution and laws of this Union, and if the editor of the Tribune ever gets before the court on a question like that, we advise him to stick fast to his own color and not presume too much upon the rights of human nature. Thus spake the voice of racism enthroned. It taunts even the whites who stand up for divine law on behalf of blacks, indeed of justice. Bitterness had turned into pure arrogant pride for those Southern writers. Should any reader get the idea that such views represented only the handful of elitists who wrote for the Southern establishment, contemplate the audience of such a newspaper, something akin to equivalent of today's Fox News or another mainstream news outlet. It was designed to appeal to the common literate masses of the day and to formulate their political talking points into piercing sound bites for them. In this issue, the triumphant slave power reduced the issue to an appeal to the slavery of the framers and the exaltation reserved for those who were both white and pro-slavery under the full enforcement power of the U.S. federal government. While the positions were not new, the passion for throwing them in the face of the North had increased to a level that was. Southern leaders were about to set the South on fire over slavery. Fire eaters and the point of no return. The lust for expansion marked the outlook of Southern slavery and racism since at least the early 19th century, and it spilled over into the program of Manifest Destiny, the effort to spread America literally from sea to shining sea, and the belief that this was destined to happen. Few people know the phrase had been coined by Southern racists on racist terms, who had even broader visions of a Southern slave empire encircling the whole Gulf of Mexico. Washington, D.C. based editorialist John L. O'Sullivan first published the phrase Manifest Destiny in an 1845 issue of his United States Magazine and Democratic Review, a propaganda arm for Democrat politics. While most Southerners on the surface supported the annexation of Texas as a slave state because it would increase the slave power, O'Sullivan argued slyly that it was actually about the voluntary abolition of slavery. One need only to read between the lines in the slightest, however, to get his real aim, and use no discernment at all to see the overt racism on the surface. Texas, he argued, would provide a place for draining off slaves from more northerly slave states, and perhaps by implication, free blacks from all northern states as well. After all, the question of what to do with the black race, once emancipated, was the question of one of emancipation's worst difficulties, if not absolutely the greatest. Texas would provide a stepping stone for removing all blacks eventually, all the way into Mexico, where everyone could be happier. The Spanish Indian American populations of Mexico, Central America, and South America were already of mixed and confused blood, and free of the prejudices which among us so insuperably forbid the social amalgamation the slaves needed. In short, annexation of Texas and of the southwestern territories generally, by implication, offered great promise for the ultimate disappearance of the Negro race from our borders. In sort of a perverted Southern version of the colonization society, O'Sullivan had argued for colonizing Texas with slaves as a way of getting rid of blacks throughout the rest of the states. Not only was this appeal certainly disingenuous, it said nothing, for example, about the practice of slavery in all the other Deep South states, or how indefinitely or cruelly it may continue in Mexico and Latin America. It made a powerfully clever, if devious, play on the racism of Northerners, most of whom could not have defended themselves against the charge of wanting to rid their states of the Negro race had they wanted to. The hope for California had been great, and remained intense even after the state was admitted as free. Some Southern leaders wished to divide it in two, making the southern half a separate slave state. About this time, President Pierce had appointed as his Secretary of War and future president, Confederate president that is, Jefferson Davis, who thought a slave market in California would soon be a thing. The secession-minded Davis called in his friend Jim Gadsden to negotiate a land acquisition from Mexico. In a race with the Northern Pacific to settle the West, the slave power needed to make a route for a southern railroad to get slaves to California and bring back gold. Gadsden had descended from a prominent Charleston family. His grandfather had been a slave trader after whom the previously mentioned Gadsden's Wharf, where slaves in 1807 had died packed on board ships and others frozen to death, had been named. James would have made the family proud when he eventually secured the Gadsden Purchase, now the southernmost section of Arizona and New Mexico, in 1854 to provide a cost-effective slave trafficking system across a whole continent. Slave owners back east, anxious for a quick profit, certainly kept California in mind. One elderly gentleman, considering the prospect of selling out his plantation, said he would wait to see if California eventually opened up, for if it did, he could sell his slaves there for twice as much as he could in New Orleans. In a similar discussion, the governor of Virginia, Henry A. Wise, reportedly told voters on the campaign trail that California would bring a boon to the domestic slave trade so popular in that state, because if slavery were permitted in California, Negroes would sell for $5,000 apiece. The Southern lust for ever-expanding slave markets manifested not only in the repeated crusades to open a new Western territories as slave states, but also in a sustained dream of incorporating all of Mexico and the Caribbean if possible. The Pierce administration was right in the middle of this too. In 1853, it sent future President James Buchanan as an ambassador to the UK to devise a plan for the U.S. to annex Cuba. A meeting held in Belgium resulted in the Ostend Manifesto, a declaration that the U.S. government intended to acquire Cuba peacefully, it hoped, but if not, by every law, human and divine, we shall be justified in wresting it from Spain if we possess the power. The declaration did not accomplish much but to anger the northern newspapers and continue to tank what little was left of Pierce's chances at re-election, not only because of increased antipathy from northern sources, but because pro-slavery forces considered the failure to follow through as a failure to the South in general. Simultaneously, Buchanan, Ostend's signatory, saw his stock begin to rise. Other elements of the slave power seemingly appeared out of nowhere to try to make the dream come true. On the 4th of July, that Garrison was burning the Constitution outside of Boston, a group of 5 conspirators met in Lexington, Kentucky, to form a secret society called the Knights of the Golden Circle, dedicated to the dream of building a slave empire that encircled all Mexico, Central America, Cuba, and the Caribbean, thus forming a golden circle of slave power in the South. The group raised money for armed expeditions to overthrow governments and form slave colonies for this goal. Again, disparate elements popped up eager to spend that cash for its intended purpose. Former governor of Mississippi, John Quitman, tried to organize a campaign to invade Cuba and was inundated with requests to join. Applications came from former Mexican war veterans and many young Southern military school graduates eager to make their mark, as well as a veritable who's who of Texas politics at the time. Despite the large support, not much came of the actual campaign. Quitman settled for a campaign for Congress instead and won. Not content with mere Congress, Tennessee's William Walker invaded Mexico and proclaimed himself President of the Republic of Baja California. He survived his ousting only to try again, this time in Nicaragua. Despite official recognition from peers, Walker could not hold down the fort. After a revolt, he eventually surrendered to American forces and was returned to the U.S. When he foolishly tried a third time, British forces captured him and handed him over to a less merciful Honduran government, which executed him. Despite the foolhardiness and failure of such men who would be kings, the dream of such a slave empire was a real enterprise with many earnest supporters and blood spilled for it. Many prominent Southern leaders, while maybe not endorsing every element of such campaigns, at least not publicly, nevertheless shared the goal of reopening the African slave trade. But since a federal act fighting the continued smuggling of slaves in 1820 had labeled any further Atlantic trade as piracy, those in favor of reopening it had to fight the additional stigma of that term. Governor Adams of South Carolina noted the moral tension in 1856. If the trade be piracy, then the slave must be plunder. The editor of one Mississippi newspaper complained of the logic. If it is wrong to buy and sell Negroes with an intention to enslave them, is it not wrong to hold them in slavery? These calculations were not admissions of guilt. They were warnings that the federal government had positioned itself to attack the institution pro-slavers held dear. As attacks from abolitionism and northern political forces mounted, these defenders of slavery entrenched themselves, not only defended the institution but longed to reopen the Atlantic to a legal trade in African slaves, with hopes that a fresh influx of supply would drive down prices and increase slave ownership even among the poorer whites. This would not only make the institution more profitable, but spread slave ownership more broadly, increasing the voting bloc, which had direct financial interest in slavery. Several prominent leaders joined this crusade. Mississippi Governor John McRae argued that buying a slave in an African market was no different morally than buying one in the market operating within the states, so why not reopen the trade? Such arguments eventually influenced some of the Southern intelligentsia. Sociologist George Fitzhugh condemned the plan to reopen as late as 1854, but was convinced only a few years later by the argument that slaveholding and slave trading must stand together or fall together, and he joined the so-called fire eaters. Indeed, by 1859, in a kind of Calhounism 2.0, Fitzhugh was arguing that reopening the transatlantic slave trade was the only measure that could save the Union. The South needed more slaves to settle more territories as slave territories. The North needed the South to have more slaves to keep the cost of slave-produced goods on which she depends for food, clothing, etc. Aside from the various political ideas, one common aim of the fire eaters was to win back the hearts and minds of Southerners who had wavered in their loyalty to slavery due to attacks from religious leaders, as well as the influence of the 1820 anti-piracy legislation. These efforts could range from persuasive appeals to the masses, like James D.B. DuBose, the interest in slavery of the Southern non-slaveholder in 1860 to strident ultimata. The editor of the Galveston Weekly in 1857, for example, drew a line in the sand. Those who are not for us must be against us. Those who deny slavery and the slave trade are enemies of the South. But all had the same goal of further radicalizing and solidifying the South on the issue of slavery. DeBow's tract aimed to prove that the interest of the poorest non-slaveholder among us is to make common cause with and die in the last trenches in defense of the slave property of his more favored neighbor. The Mudsill and the Cornerstone. On May 4, 1858, only 2 days prior to the Dred Scott decision, James Hammond had given his Cotton is King speech on the Senate floor. Pro-slavery forces had submitted a bill trying to muscle through the admission of Kansas as a slave state. President Buchanan had given the bill his blessing while publicly supporting a free Kansas. Still operating on the agenda of Calhoun's advice, Hammond condemned opponents of the bill as agitators against slavery and stated that he refused to discuss the issue on any other terms than as a thing that is and is to be, and on the assumption of slavery being ineradicable from American institutions. He then proceeded to announce his fealty to King Cotton and to boast of his monarch's invincibility on the international scene. His power, Hammond proclaimed, exceeded even that of the previous reigning monarch, the Bank of England, as well as all the financial institutions of the North. Yet as all-powerful as men like Hammond may have perceived King Cotton, they also trusted an even greater economic power. But, sir, the greatest strength of the South arises from the harmony of her political and social institutions, meaning slavery. Or as Hammond put it, in all social systems, there must be a class to do the menial duties, to perform the drudgery of life. That is, a class requiring but a low order of intellect and but little skill. Its requisites are vigor, docility, fidelity. Such a class you must have, or you will not have that other class which leads progress, civilization, and refinement. It constitutes the very mudsill of society and of political government, and you might as well attempt to build a house in the air as to build either the one or the other, except on this mudsill. For these comments, history remembers Hammond's Cotton is King speech even more famously as the Mudsill speech. Hammond launched into the whole racial justification, oblivious to the fact that within days the tide of national sentiment would be turning against the system for good. Fortunately for the South, she found a race adapted to that purpose to her hand, a race inferior to her own, but eminently qualified in temper, in vigor, in docility, in capacity to stand the climate, to answer all her purposes. We use them for our purpose and call them slaves. Following Calhoun's lead, Hammond argued that slavery provided a positive good not only for the ruling whites, but for the Africans themselves. We do not think that whites should be slaves, either by law or necessity. Our slaves are black, of another and inferior race. The status in which we have placed them is an elevation. They are elevated from the condition in which God first created them by being made our slaves. None of that race on the whole face of the globe can be compared with the slaves of the South. They are happy, content, unaspiring, and utterly incapable from the intellectual weakness to ever give us any trouble by their aspirations. Not only was this nonsense among people familiar with Southern slavery, it was fading from acceptance on the national scene as well. Hammond's suspicion that the anti-slavery forces had grown in power in Congress rang true, and appeared in, among other places, the speech of a rising Republican. Abraham Lincoln, who had debated and lost the Senate race to Stephen Douglas only the year before, nevertheless established himself in various ways, essentially began campaigning for the 1860 presidency within a few months. In September of 1859, he stumped before a group of Wisconsin farmers on labor and agriculture. In that speech, he referred to the mudsill theory as the view that all labor, hired or slave, is fatally fixed in that condition for a life, and thence again that his condition is as bad as or worse than that of a slave. By this theory, he said, it is assumed that labor and education are incompatible, and any practical combination of them impossible. He built upon this. But free labor says no. Free labor argues that, as the author of Man makes every individual with one head and one pair of hands, it was probably intended that heads and hands could cooperate as friends. Every head should be cultivated and improved by whatever will add to its capacity for performing its charge. In one word, free labor insists on universal education. Lincoln's views against slavery had been well known for some time, at least since his explicit speech in Peoria in 1854. During his debates in 1858, Douglas condemned him as an abolitionist, even as a closet abolitionist. With continued pronouncements like these against the latest of slave arguments, Lincoln kept his position in the fore, even with more moderate tongue, in a way every Southern partisan could understand. There is no wonder that his mere election in 1860 would be enough to push South Carolina over the edge of secession. She would do whatever necessary to protect the institution. Northern complicity. Throughout the antebellum era, the North may have combated the institution of slavery in various ways and to various degrees. Certainly, abolition arose in the North, and as far as it fanned the flames of resentment over pro-slavery legislative encroachments, it can be said to have prevailed. But two facts at least remain and stand out in history regarding its complicity in slavery. First was the continued complicity in the slave trade. Even after Congress officially closed it, this remnant would always stand for the legacy that the North had always trafficked in slaves delivered to the South, and even while the remnants of the Northern traders continued black market deliveries, their Northern neighbors and friends in Congress were condemning the South for upholding the very slaves they sold them. Second, even if we accept the common misconception that slavery abruptly ended in the North's emancipation efforts, it did not, as we saw in the last chapter. The North actually led the way in developing a plethora of segregation laws, paving the way for the South to follow as soon as Reconstruction began. This means that while the North may have gotten rid of slavery, it still suffered from the racism that the Southerners used to justify the institution. When reminded of this, Northern leaders would be hard-pressed to give a good answer. We will address the second issue of segregation and racism in the next chapter. For now, let us look at just one prominent example of how a Southerner used the North's participation in the slave trade against them in this era. Taney's Dred Scott decision ultimately implicated the North and the whole British Empire. Whether consciously or not, it exposed the hypocrisy of continued racism that, first, had formed the foundation of the constitutional compromises to begin with, and second, still pervaded the North as well. This opinion of African inferiority was at the time fixed and universal in the civilized portion of the white race. It was regarded as an axiom in morals as well as in politics, which no one thought of disputing or supposed to be open to dispute, and men in every grade and position in society daily and habitually acted upon it in their private pursuits as well as in matters of public concern, without doubting for a moment the correctness of this opinion. Remember, our earlier thought experiment with the carpenter and all of the northern economy that depended on and profited from the slave trade and slavery. Taney simply here reminded everyone of the private pursuits that daily and habitually consented to the subjection of the African race. He continued to press the issue, making clear that profit lay at the heart of it. Said Taney, and in no nation was this opinion more firmly fixed or more uniformly acted upon than by the English government and English people. They not only seized them on the coast of Africa and sold them or held them in slavery for their own use, but they took them as ordinary articles of merchandise to every country where they could make a profit on them. By this universal consent, in both word and practice, Taney deduced an equivalence between being of African descent and being a slave. The opinion thus entertained and acted upon in England was naturally impressed upon the colonies they founded on this side of the Atlantic, and accordingly, a Negro of the African race was regarded by them as an article of property and held and bought and sold as such in every one of the 13 colonies which united in the Declaration of Independence and afterwards formed the Constitution of the United States. The slaves were more or less numerous in the different colonies as slave labor was found more or less profitable, but no one seems to have doubted the correctness of the prevailing opinion of the time. This, the Supreme Court decided, was the law and reality of the American people and the law of the land known as the Constitution, that being black meant that you were an article of property. Most importantly, Taney's decision not only rang true historically on his point, but it revealed that the North, too, had been willing, knowing, and complicit in the peculiar institution from the beginning, and had written that same attitude organically into their Constitution. Conclusion. To the event that the Antebellum era was truly an extended escalations of the tensions inherent in the constitutional settlement, we would expect an inevitable rift over slavery. No matter what governmental elements, legislation, judiciary, the executive, the meaning of the Constitution itself, etc., come into play, when the irresistible force and the immovable object collide, then write a Constitution together purporting to comprehend the whole nature of each in a single union, there is going to be an explosion eventually. Indeed, some of the prominent critics of the Constitution in its formative days predicted it would lead to a civil war. Given what we now know about the attitude of some of the slave states and the allied slave trading states at the time, we could probably have predicted that such a war would erupt over the issue of slavery, specifically as an argument over whether the Constitution really protected it indefinitely or not. To be sure, when the issue of secession finally arose as a reality, not everyone among the Southern pro-slavery forces thought leaving the protections of the Constitution was wise. Some desired to remain in the Union, specifically because they believed it would better secure the perpetuity of slavery. They saw the institution's greatest protection in nothing less than the Constitution itself. After all, had Taney not just settled the issue of that document's original intent and plain meaning? Leave that behind, and who knows what the future could hold. Or more to the point, perhaps they did foresee what the future would hold. Virginia slave owner and Congressman John S. Carlisle argued in the Secession Convention, how long, if you were to dissolve this union, would African slavery have a foothold in this portion of the land? I venture the assertion that it would not exist in Virginia 5 years after separation, and nowhere in the southern states 20 years after. In the more isolated position of a new, smaller, independent nation, the South would not stand alone against the North only, but the whole world. How could it maintain itself with the whole civilized world backed by what they call their international law arrayed for its ultimate extinction? At least in the Union, the North and the Constitution provided some semblance of protection against these forces. Whether pro or con, slavery was always the primary issue. Had the South not threatened secession since before there was a Union, since the earliest of the Continental Congress and Constitutional Convention over this very issue, had it not recurred in nearly every major national debate since then? Had not the arguments over its expansion and practices, the rights of owners, the return of fugitives, etc., spanned and punctuated every decade since, often multiple times? Had not the most prominent of Southern leaders, like Calhoun, sounded the highest alert and direst threats repeatedly since the rise of abolition? For his part, Confederate Vice President Alexander Stephens made it unmistakably clear what role slavery played for the newly seceded South. The new Constitution has put at rest forever all the agitating questions relating to our peculiar institution, African slavery as it exists among us, to the proper status of the Negro in our form of civilization. This was the immediate cause of the late rupture and present revolution. He then referred to Thomas Jefferson, who had led the revolutionary sentiment against the institution, at least in theory. The prevailing ideas entertained by him and most of the leading statesmen at the time of the formation of the old Constitution were that the enslavement of the African was in violation of the laws of nature, that it was wrong in principle, socially, morally, and politically. It was an evil they knew not well how to deal with, but the general opinion of the men of that day was that somehow or other, the order of providence, the institution would be evanescent and pass away. This idea, though not incorporated in the Constitution, was the prevailing idea at the time. On behalf of his new nation, Stephens expressed exactly what he thought about this prevailing idea. Those ideas, however, were fundamentally wrong. They rested upon the assumption of the equality of races. This was an error. It was a sandy foundation, and the government built upon it fell when the storm came and the wind blew. What then of the Confederacy? Stephens then followed with the part for which his speech is most famous. Our new government is founded upon exactly the opposite idea. Its foundations are laid. Its cornerstone rests upon the great truth that the Negro is not equal to the white man, that slavery, subordination to the superior race, is his natural and normal condition. This is what Southern cessationism is in a nutshell. Slavery was the cause. The suppression of the black race was the cause. The framers thought slavery should someday end. The framers were dead wrong, and the documents they wrote defective. The races are not equal. The Confederacy will be founded precisely to right this wrong. Slavery and suppression of blacks are the cornerstone of the new Confederacy. And abolition? Well, that is a species of insanity. If you take Carlyle's view, the Constitution protected slavery. If you take Stephens' view, the Constitution still did, but the sentiments in the Declaration had corrupted the application of it. The new Confederate Constitution would remedy this defect. In whatever case you accepted, Garrison's prophecy of our covenant with death remained true. Only the insanity of abolition could make a profit in these days, unless we were to include the self-fulfilling variety of Calhoun and all those like him. There was more at stake, however, than just the Constitution and the end of slavery, as Stevens and so many others had made clear. American slavery was specifically racist slavery. It could not exist apart from racism, and could not be separated from it. Slavery was a massive institution, but its evil was only enabled by the constraints of law and power. Change the law, and you can end the slavery, for the slavery rested on law. But racism rests in the heart and mind. You can change laws, but changing hearts is a whole different matter. Once the slavery was taken away, the racism still existed. The hearts of millions of whites hated and despised blacks just as before, only now even more so. Now they would have the added insult of an occupying government and military force attempting to make them live as equals, politically at the very least. If the racism remained unrepentant and unhealed, and it certainly did, the evil would only manifest in a new way. If racism had driven men to do something so pervasively evil as that found in the history of American slavery, the atrocities and tragedies recorded in the pages of this book, and much more, what would prevent it from new expressions of its evil once slavery was taken away? Indeed, not only would nothing prevent it, but the same evil had already set precedents for it in the North. Southerners were about to become quick learners.
The Reconstructionist Radio Podcast Network brings to you a complete lineup of podcasts where you will hear practical and tactical theology. Our desire is not simply that you consume our shows, but that you also live out your faith in every area of life. We can talk all day long about these things, but if we fail to put them into practice, then we fail as ambassadors of Jesus Christ, our King. Subscribe now to your favorite Reconstructionist Radio Podcast Network shows, or you can subscribe to the Reconstructionist Radio Master Feed, where all of the content we produce, including the audiobooks and audio articles, will pop up as soon as they are available. And don't forget to visit ReconstructionistRadio.com to volunteer as a narrator or to partner with this ministry financially. May the Holy Spirit stir you into action for Christ and His kingdom.